is actually a term of the contract, or is it simply a representation? And remember why we said it's important to differentiate between a term and representation. It's going to matter because if it's a term, the remedy will be different. If it's a representation, it's not legally binding term, and therefore the remedy will be with respect to misrepresentation. Now, we see two illustrations here. We're going to look at two particular cases. And in these two particular cases that we look at, Oscar Chess and Harold Bentley and Harold Smith Motors, we're going to see two cases with really similar facts in both of the cases, but actually a different outcome in the two cases. So the first case we're going to look at is the case of Oscar Chess and Williams. Now, this case, it involved a private person who was selling a car to the garage. And this private individual, he believed that the car was a 1948 model, but in fact, it was actually a 39 model car. And the garage sued for breach of contract, and the garage claimed that the statement as to the age of that car was a term of the contract. Okay, so facts again, we have a private party sold a car to the garage, and this private party believed that it was a car from the 1948, when in fact the garage subsequently found out that the car was actually an older model. It was a 1939 model, and the garage sued the private party. They sued for a breach of contract. They claimed that the garage's claim was that this statement that the car was a 1948 model was a term of the contract. So the matter went to court, and the court said, well, on the basis of the facts here, he said the garage was the person with the greatest skill and with the greatest knowledge of such matters. And the court said that given that the garage were the party with the greater skill and with the greater levels of knowledge about such matters, the court decided that this statement couldn't be regarded as a term. And the court said all of this week certainly guys, an intelligent person next week standing by will still looking at it all in the areas wouldn't contract law that the seller intended after we have contract law completed, we will be moving into the area of employment law. And once we have this person selling the car, this private party who was selling the car, wasn't able to then guarantee the age of the car, because the only thing he had to rely on were the car registration documents, and he had no means of ascertaining or no means of actually determining if these documents were actually accurate. And the court said that, on the other hand, the purchaser, who was the garage in this case, the court said that given that the purchaser was in the motor trade and had been for many years, they could have taken the engine and the chassis numbers and checked with the manufacturer. So the court ruled here that this statement that the car was a 1948 model wasn't actually a term of the contract. And the court reasoned that because they took into account the maker of the statement, and they felt that actually the dealer here, the defendant, had the greater chance of checking out the age of the car. Now, in the other case, the later case of Dick Bentley and Harold Smith Motors, here the plaintiff bought a car from the defendants and relied on a statement that had been made about the mileage of the car. And unfortunately, subsequently, this statement turned out to be untrue. And the plaintiff had been told here in this case that the car had only done 20,000 miles since major repair. In fact, the car had done something closer to 100,000 miles since the refit, since the major repair. So issue again in this case was, did that statement amount to a term, or was it a representation? Now, what's the relevance? If that statement was a term of the contract, there would be damages for breach of the contract. And if it was a representation, there would be no damages payable. So it fell to the court to decide this. So the court said here that the appropriate test that should be applied is, would an intelligent bystander infer that the statement was intended to be contractual. So the court said, what would an intelligent bystander have thought? Would they have thought that this statement was intended to be contractual? So applying that test, the court came to the conclusion that the statement as to the mileage, that actually was a term of the contract on the basis that the defendant here was a car dealer who should be taken to have better knowledge of such matters than the plaintiff. So given the levels of knowledge, expertise and skill of the defendant, they would have better knowledge, better familiarity with these things than the plaintiff, who wasn't actually involved in the motor trade. So the court reasoned here that the defendant, the car dealer, had greater expertise, and the plaintiff in this case had relied on that expertise. Okay, so therefore, in this case, the statement that was made was found to be a term of the contract, given who actually made given that term. Okay, no, I haven't taken attendance just yet today. Okay, so somebody has just put that in the chat. I haven't missed attendance. No one has missed the attendance because I haven't got around to doing that just yet. Okay. Sorry, my slides are stuck, guys. I can't seem to move them on. Okay, now we're going to move on, folks, and we're going to look at express and implied terms. The express terms, when it comes to contracts, the express terms are the terms that the parties specifically have agreed between themselves, and they're known as express terms. These express terms can be agreed verbally or in writing, and like an example of an express term might be the consideration or the agreed price. So for example, in a contract for the purchase of a house, an express term of that contract would be that the house is going to cost 150,000. Now it is to be recognised, however, that express terms will be categorised as conditions or warranties depending upon the importance of the term. So not all of them are considered actually to be equal. And the courts haven't found it easy to see whether a term is actually a condition or a warranty. And sometimes some terms are called actually inanimate or intermediate terms. So in other words, they're not classified until such time as there's a breach, and the significance of that is considered then at that stage. Okay, so the importance of this distinction between conditions and warranties relates to the different remedies available depending upon there's a breach of warranty or depending upon whether there's actually a breach of a condition. So what we're looking at here, folks, we're looking at terms, we're looking at whether it's a condition, whether it's a warranty, and the relevance of that. Why is it relevant? Whether something is a condition or warranty depends on the remedy that's available. And, you know, going out into the future, when you'll have contracts and so on and so forth, negotiating contracts and writing contracts and reviewing contracts and so forth, it's important to have a level of understanding so that you know what sort of remedy is going to be available in the event that there is actually a breach of it. Okay, so what we look at now, folks, is we're going to look at conditions, warranties, and intermediate and inanimate or intermediate terms. Okay, so I'm on slide 19. I jumped around there for a moment just to show you what I was going to talk about for a few minutes. Right, so what do we mean by conditions? So it's conditions we are focusing on at this stage, guys. So if anyone is a bit lost and wondering, what are we talking about now? We're talking about terms in a contract. We're talking about whether that term is actually a condition or warranty. The reason we're talking about the distinction as to whether it's a condition or warranty is because the remedy will differ depending upon whether the term is actually a condition or a warranty. Okay, so now, folks, right, what can we say about conditions? These are your most important terms of the contract, okay? And these are the terms that usually go to the heart of the contract. In other words, they go to the root or they go to the very essence of the contract. Okay, so they're very, very significant, very, very substantive part of the contract. And if there is a breach of a condition, what are the consequences? Well, if there is a breach of condition, the injured party can repudiate the contract and sue for damages, or they can go ahead with the contract and still sue for damages. For anyone who's out there and is unsure what this term repudiation means, basically means to, destroy the contract, to end the contract. Okay, so a breach of a condition can lead to essentially the discharge of the contract or the end of the contract, and you can also claim for damages. Like conditions are generally the very, very fundamental terms in a contract. So for example, selling price of a house, and if there was a breach of that, it would have major consequences. Okay. So for example, like in the sale of a house, we might agree that the sale of the house is 150,000. And then if that's breached, like someone saying, oh, it's 140 and only willing to pay that, could lead to the repudiation of the contract. Okay. The consumer legislation also steps in here as well, and it classifies certain terms as conditions, and you can't contract out of that. Well, we look at a case whereby a breach of condition arose. And again, just to reiterate it again as to what a condition is, and to remind you all again that a condition is a major term of the contract, and the breach entitles the innocent party to set aside that contract and to claim for damages. In other words, to sue for damages, sue for compensation. So a case where this was considered was in the case of Poussard and Spears and Pond, and the plaintiff here was contracted to sing in an opera for a period of 3 months. So Poussard, she was contracted to sing in an opera and for a period of 3 months. Now, unfortunately, she became ill, and as a result, she wasn't actually able to attend on the opening night or the first 4 nights in all. And consequently, the opera company hired a substitute and terminated her contract. And she sued for a breach of contract and she claimed damages. And the court held here that she had breached a condition of the contract by failing to sing on the opening night. And the court said that this was a significant part of the contract, that the opera contract was entitled to actually terminate the contract. Okay, so the court said here that the obligation to attend on the opening nights was a term of the contract and therefore was a condition. And the fact that this condition was broken, it entitled the opera company, i.e. the defendants, it entitled them to actually end the contract. So the case of Poussard and Spears, the relevance of it is, or what does it illustrate, or what rule is being demonstrated in this case? In this case, it's demonstrating the rule or demonstrating the principle that where a condition of a contract has been breached, the injured party can set aside the contract and can claim for damages. Okay, so in this case, the opera company were entitled to have that contract actually discharged, okay, because there had been a breach of condition. And then on the other hand, we can also have warranties in a contract. And what are the warranties? And the warranties are generally considered to be the less vital terms when it comes to the contract. They're kind of regarded as more ancillary terms of a contract. They're not usually the terms that persuade somebody to actually enter the contract. What is the difference between a breach of condition and a breach of warranty? The remedy is for damages only. In other words, you're not entitled to repudiate, you're not entitled to end, you're not entitled to actually discharge the contract. Okay, you can only claim for the loss or for the damages that are suffered. And why is that? yeah, you might wonder there as you're listening to this, you might wonder, well, why does a breach of warranty not entitle you to repudiate the contract? And the reason for that seems to be that it doesn't usually have the serious consequences that a breach of condition can have on an injured party. And that's illustrated here in this case of Bettini and Guy. And Bettini, like the previous case, was also an opera singer, and he was contracted to perform in an opera for one season. And he agreed to attend a week of rehearsals prior to the opening night. However, he became ill and he was only able to attend the latter part of the rehearsals. So he missed 4, but he was able to complete 2. Now, the defendant terminated the contract, and the court held that this requirement and this term to attend the rehearsals, that it wasn't such an important part of the contract, and that this failure amounted to a breach of warranty and not a breach of condition. So the court ruled here that therefore the defendant had no right to repudiate the contract. Okay, so you see a distinction there between the two. You see a distinction there between the two cases in Bettini and Guy and Poussard. In this case that we have here, Bettini, we have a breach of warranty. And the attitude of the court there with a breach of warranty is that it entitles you to claim for damages only. So even though the terms of the facts of those two cases are rather similar, different conclusions are reached in both, because in one you have a condition and in the other you actually have a warranty. So now, folks, before I move on to inanimate terms, I'm going to launch the poll so that you can confirm your attendance. Okay, so I'll just give you a moment now to do that. Okay, thanks for doing that, guys. Okay, so then folks, you can also have such thing as inanimate or intermediate terms. It's not always possible for the court to see whether the term is a condition or warranty, and the courts have come up with this concept of an inanimate term. It basically means that it's an unclassified term and it's not classified until it's breached. If the inanimate term is breached, the injured party can claim damages, and if depending on the nature and the consequences of the breach, they might also have the right to repudiate the contract. Okay, so if the breach of a term of the contract, if it deprives the injured party of the whole benefit of the contract, the court is more likely to treat the breach of the inanimate term like a breach of condition, and then the party will be able to actually have the contract discharged and look for damages. But if the court sees that they didn't actually lose the entire benefit of the contract, they'll treat it like a breach of warranty and allow them to claim damages only. So where do the courts come up with this idea of inanimate terms? And it came up for consideration in this case here of Hong Kong Fur Shipping Company Limited and Kawasaki. In this case, the defendant chartered a vessel from the plaintiffs for 2 years. And the contract stated that the vessel would be fitted in every way for ordinary cargo service. Okay, so that was stated in the contract, that the vessel would be in every way fitted for ordinary cargo service. Now, it turned out actually that it wasn't, and it actually took it a while for repair. I think it took it about 4 months, about 4 months essentially, for the vessel to be repaired. So the defendants terminated the contract, and the plaintiffs brought an action and said that there had been wrongful termination here. And the court held that the damage suffered by the defendants was not serious enough to give them the right to actually repudiate the contract. The court said that the defendants still had a lengthy period to run on this contract, that they had still had capable voyage time left, and the court said that the breach here was actually a breach of warranty and not a condition, and therefore, because it was a breach of warranty, they were only entitled to an award of damages. Okay. Now, in the Irish case of Irish Telephone Rentals and Irish Civil Service Building Society Limited, the telephone system broke down, and this was considered to be a breach of a term in the contract that stated that goods were to be of merchantable quality. And the court said that this was an inanimate term, but they said that the injured party, had a right to repudiate the contract because the consequences of this lack of merchantable quality were sufficiently serious. So therefore, the court allowed them to actually terminate this contract. Okay, so that's what arose, because the court said it was a breach of condition entitled to terminate the contract because the breach of it was so fundamental to the performance of the contract. Okay, now terms can also be implied into a contract. And why is it necessary to imply terms into a contract? Because these are the terms that are not actually agreed between the parties, but nonetheless they're actually deemed to be part of the contract. And these terms can be implied into the contract from various sources. They can be implied into the contract by the courts, by legislation, by the Constitution, or by custom. And why is a term implied into the contract? And they are as important as the express terms. If there's, it might be that the courts might actually imply a term into a contract in order to make the contract work. So the court will say that if it's necessary to make the contract work, the courts will imply a term into the contract. If it's necessary to give the contract meaning or to make the contract sense, the court might actually imply a term into the contract. Now, legislation also implies certain terms into the contract. So, for example, in your employment type contracts, certain terms apply irrespective of the intentions of the parties. So like for the Organisation of Working Time Act 1997, so things such as, leave and pay and notice, etc. These apply irrespective of the intentions of the parties. Sale of Goods and Supply of Services Act 1980, it implies terms into a contract, like, for example, that goods are to be of merchantable quality, and you can't actually contract out of these terms that are implied into the consumer contracts. And similarly, landlord and tenant contracts, Residential Tenancies Act, when a private property is being let, a term will be implied into that contract that the property is safe, that the property is fit for human habitation. And just to make you aware as well that terms can also be implied by the Constitution. Okay, the right to you have the right to join a union, and as well you have the right to decide not to join a trade union. And then terms can also be implied through custom. Okay, so terms that are customarily found in contracts within a particular market, trade, or locality, they can be implied into a contract. Okay, I'm not going to dwell there on the implied terms, guys. So I'm not going to focus any longer on those. But where I am going to spend more time now, folks, is I'm going to start looking at exclusion clauses with you. Okay. And exclusion clauses are something you come across quite regularly, and you'd see these a lot. Anyone who has ever gone to Houston Station, or anyone who's gone to an airport, or if you've been in the dressing room in a swimming pool, a gym, a GA club, you probably come across an exclusion clause. And an exclusion clause are one of those clauses like that contain words such as "we cannot accept any liability for any loss howsoever caused." That would be an example of an exclusion clause. Okay, so it might be that we cannot accept liability for any loss of valuables. You know, when you go to the swimming pool, there might be an exclusion clause in the changing rooms, that saying that they can't accept any liability for loss of valuables. Those type of things. That's what we mean by exclusion clauses. So when would you use an exclusion clause? You might use an exclusion clause in your contract if you want to reduce your liability or you want to avoid liability. That's why somebody will use an exemption clause or an exclusion clause. I use this term exclusion clause and exemption clause. They both mean the same thing essentially, and they're quite interchangeable. So you will come across these exclusion clauses in a wide variety of contexts. Like you could come across them in telephone contracts, in broadband contracts, you could come across them car parks quite a lot, public transport, public places like airports, train stations. All of those places might actually contain an exclusion clause. It might be that, you know, you have, it might be that, for example, say in 2 years' time, you're working as a business development manager in a company like, for example, a courier company, and a brief falls on your desk whereby one of the drivers delivered goods to a customer in Longford, and the customer in Longford has contacted your delivery company now to tell you that everything that was delivered to her arrived broken. Okay, and like while you know, your job then will be to see in the terms of delivery, is there an exclusion clause there, and does it cover you? Does it cover you for the liability? Will you be held responsible for that, or will it be the actual provider of those goods who will be responsible for that? So that's when an exclusion clause could become relevant to you, depending upon what type of business you're in, depending on your insurance, depending upon what the area of business you're in, you may well come in contact with an exclusion clause. So court dislikes them. Courts very much dislike exclusion clauses. Why? Because if you think about it, the exclusion clauses are generally inserted into contracts by the more powerful or the more experienced or the person with the greater bargaining power, and can take advantage or can manipulate the weaker party to the contract. So the courts tend to disapprove of them, and therefore the courts have put in place fairly strict rules governing the validity of the exclusion clauses. So the courts will want to check first, is it a term of the contract, and does it cover the breach? So there's certain things for an exclusion, for you to be able to rely on your exclusion clause and to exempt yourself from liability, you'll have to demonstrate, yeah, it was a term of the contract, and secondly, that it's worded to cover the breach. Now, so as I was saying there about the exclusion clauses, that they are disliked by the courts, but at the same time, the court recognises that parties have freedom to contract. And they're free to contract on whatever terms and conditions that they actually want. So again, Jen, just to reiterate what an exclusion clause actually is, and it's a clause that's used in a contract and whereby it attempts to limit or to restrict the liability under the contract in the event that there's a breach of the contract. Okay, so it's essentially it's an attempt to reduce or to limit the liability in the event that there's a breach of the contract. Okay, so what are then, we move on, folks, and we look at these exclusion clauses in more depth. So as I was saying there, folks, in order for you to be able to rely on the exclusion clause, so in order to say that you have no liability and to say this exclusion clause carries weight, you have to actually be able to demonstrate that, one, the exclusion clause is a term of the contract. In other words, you have to satisfy these rules of incorporation. You have to show that it has been validly incorporated into the contract through one of the means of incorporation, which can be by notice, by signature, or through a course of dealing. Now, we'll look at the rules of incorporation in a few moments, and we'll also look at the rules of construction. So the exclusion clause has to be, one, incorporated into the contract. In other words, it must be made a part of the contract. In other words, it must be actually a specific term of the contract. And secondly, then, the exclusion clause must also be incorporated so that it covers the breach. And by constructed means that it must be worded in such a way that it covers the breach. So it must be constructed, or it must be interpreted in such a way that it actually covers the breach. Okay. So let's look then, folks, at the rules of incorporation. And there's various ways in which an exemption clause can be incorporated into a contract. And it could be by actual notice, and that could be either by signature or by bringing it to the attention of the party. Okay, so basically what I'm saying to you here, folks, is that if you want to rely on an exclusion clause, you have to be in a position to provide evidence and to point out that it really is a part of the contract. So that's what we're talking about here when we're looking at the rules of incorporation. You want to rely on this exclusion clause. Therefore, if you want to rely on this exclusion clause, you've got to provide the evidence. And you've got to provide the evidence and point out that it really is a part of that contract. So going back to that example that I gave a while ago, where I said that you're the business development manager and a customer in Longford, has complained that her delivery of lights that she ordered have arrived and they're all broken. And there might be a dispute then going on between yourself, the customer, and we'll say the supplier of those goods. And if you want to rely on your exemption clause, your exclusion clause, you've got to show that exemption clause or that exclusion clause is actually a term of the contract. So it can be a term of the contract through signature, through notice, or indeed it could be through a course of dealings. Okay, the previous course of dealings. Okay, so these are the various ways in which an exclusion clause can be incorporated into a contract. So the first area we're going to look at, folks, is when you have a contract containing an exemption clause and the contract is signed. What is the rule here? And the principle here is that a person who signs a contract is bound by it, depending upon whether they've read the terms or not. They're bound by through their signature. So if you sign a contract without actually reading it, and that contract contains an exclusion clause, that clause will still be considered to be validly incorporated into the contract. Now, I know that's harsh. Like, I don't dispute that. I know that's actually harsh, but it's actually based on the principle of law, caveat emptor, which basically means caveat or buyer beware. So this rule here that if you sign a contract and there's an exclusion clause in it, that exclusion clause is going to be binding on you. Okay, so a contract that contains an exemption clause is valid. The injured party has signed the contract, and that signature can arise nowadays, can arise in writing, or indeed it could be arising by electronic means. So, for example, ordering goods on a website, and when you tick the box confirming that they agree to the terms and conditions of the contract, that can constitute an electronic signature. And if you sign without actually reading the contract, the clause will still be considered validly incorporated into the contract. And this case, that's on the slide here in front of you, this case of Lestrange and Graucup, this case concerned the effect of signature on contracting parties. And the plaintiff bought an automatic cigarette vending machine for her cafe. And she signed a contract which included an exemption clause, and the exclusion clause said that the manufacturers disclaimed all liability for the malfunction of the machine. So as it turned out, the machine didn't work, and the plaintiff sued and claimed damages. And the court said here that where the document is signed, it's immaterial that she hadn't actually read it and doesn't actually know its contents. And the court ruled here that she was bound by it. So the court ruled that it was the responsibility of the plaintiff to read the terms and conditions before she signed. And as she had signed the contract, the clause was validly included in her contract. So you see here, therefore, that this case illustrates that once you sign a contract containing an exclusion clause, you're bound by that. You're then bound by that. Okay, so this rule that you're bound by it, even if you haven't actually read it, this applies if the signing party didn't read the contract, as the presumption in law is that once you have signed something, you have agreed to it. Okay, so that's the rule there, folks. Now, there is an exception to that. Okay, so there is an exception to that. And the exception to that will be if you were induced to sign something and it was actually a misrepresentation. So this case of Curtis and Chemical Cleaning Company, this case actually illustrates a party being able to actually overcome that rule that we saw there in Lestrange. So in Curtis and Chemical Cleaning Company, this case involved the plaintiff who left her wedding dress in to be cleaned by the defendant, and she was asked to sign a receipt that excluded liability on the cleaner's part. And she asked, what is this about? And she was told that it exempted liability for the delicate beads and the sequins on the dress. And the plaintiff said, okay, and she agreed to it. Now, when the plaintiff arrived to collect her dress, what she discovered was that the beads and the sequins were all there and they were intact. But in fact, actually, the skirt had been badly stained. And the defendants argued that the exemption clause, the exclusion clause, actually covered all of this, that it covered such a situation. And the court held here that, the plaintiff, she had actually been misled into signing the receipt, and therefore it wasn't actually binding on her. So the scope of the exemption clause had been misrepresented by the defendants here, and therefore it wasn't binding because it was a misrepresentation. So we see that rule there on signature actually being overcome. Now, with the benefit of EU law, EU law has legislated and provides too that you can't have unfair terms in consumer contracts regulations. So there is these rules here that we're looking at are what we call common law rules. They're rules that have developed through the cases and through the courts, but there is also additional protections out there through EU law for our customers. Now, what about, we'll say, an exemption clause in an unsigned document, like in a ticket that you might get, we'll say, at or like at a hotel. And the rule here is that a party should be given reasonable notice of the clause either before or at the time that the contract was concluded. So reasonable and sufficient notice of the exclusion clause should be given. Okay, so now timing is very important here with this in terms of giving notice of an exclusion clause, and it's very important that that the notice of the exclusion clause is given either before or at the time that the contract was being made or was being concluded. Okay, so in an oral contract, you know, the parties would be bound if it's brought to their attention in advance. Now, so folks, it's just coming up, it's just gone 10 to 3. So I suggest we'll take a 10-minute break, folks, and then we'll get back to it. So give everyone 10 minutes, okay? So I'll turn off the camera and I'll mute this so that you can have a break, okay? Now, folks, okay, so we get right back into it again, and we're still talking about exclusion clauses. And specifically, just to remind you again, an exclusion clause is a clause whereby the party who seeks to rely on it is trying to cut back on their liability. In other words, they're trying to say, I'm not liable because of this exclusion clause, that I had this disclaimer in the contract, and therefore it exonerates me or it exempts me from liability. But the law, the attitude of the law is that, well, if you want to rely on the exclusion. There's somebody out there who might want to mute their microphone. And then his hippocampus shuts down. So we were just saying there that with the exclusion clauses, the attitude of the law then is that if you want to rely on it, you've got to be able to provide evidence of it. In other words, that you've got to be able to provide evidence that, yep, it is part of the contract. And secondly, that it actually covers that breach, or it does actually cover the breach that is being complained of, or that is being complained about. Okay. Now, with regard, the law has said that in determining whether reasonable notice was given, the courts will have regard to all of the circumstances, and the courts will have regard to whether the clause was obscured. Was it possible to read it? Was it prominently displayed, or was it hidden amongst a mass of printed material? So these are some of the factors that the courts will consider with respect to exclusion clauses. Okay, so some additional matters that the courts will ask with regards to the exclusion clauses. Now, okay, we're going to talk about exclusion clauses and time. Timing is really important. And there is a requirement there that with an exclusion clause, that notice of the exclusion clause is given to the other party, that you can't expect them to just suddenly know about it. It's important that notice of the exclusion clause comes to the other party either before or at the time of entering into the contract, and not afterwards. And this is well illustrated in Ollie and Marlborough Court. This case illustrates where the exclusion clause wasn't actually, notice of it wasn't actually provided in time. This case involves a couple who were on their holidays. They were staying in this hotel, and when they arrived at the hotel, they paid for their room in advance. And when they were in their bedroom, there was a sign that disclaimed liability for loss of valuables. So one night, the couple went out, and the female party, the wife, she locked the room and she left the key into the reception. And unfortunately, key was stolen and her fur coat was taken from the room. Now, the hotel said, we have an exclusion clause, and the hotel were really trying to rely on the exclusion clause, because the hotel said, we have an exclusion clause. And the issue was that exclusion clause actually part of our contract? And the court found that the exclusion clause could only be seen after the contract was actually concluded and you entered your hotel room. So therefore, the court ruled in this case that this clause wasn't actually incorporated into the contract. So in Ollie and Marlborough Court, this case illustrates that the exclusion clause wasn't incorporated into the contract. In other words, it wasn't a term of the contract because notice of it came too late. It came after the contract had been concluded. And bearing in mind, the couple arrived at the hotel and they paid for their room then. Therefore, the court ruled that the contract had been completed at that time. So therefore, the case illustrates to us and demonstrates to us that timing and when notice of the exclusion clause is actually given. And similarly, in Thornton and Shoe Lane parking, this case, again, the critical issue of the timing and when notice of the exclusion clause was provided arises again in the Thornton case. Here, the plaintiff parked his car in a multi-storey car park, and outside the car park, there was a notice displaying the charges and also stating that all cars are parked at owner's risk. So that was the sign outside. And then inside, from an automatic vending machine, the plaintiff was given a ticket which stated in really, really very, very small print, and that that the issue, in other words, that parking and having this ticket was subject to the conditions displayed on the premises. Now, the conditions displayed on the premises, they were displayed on pillars inside the car park. So there was additional conditions, and those additional conditions excluded liability for personal injuries, negligence, and so forth. And in the case anyway, when the plaintiff was collecting his car, he was badly injured in an accident. So litigation arose then, and he took an action against Shoe Lane Parking Limited. Why was he suing? He was suing for his losses because he had been injured. And of course, what did the Shoe Lane Parking Limited, the company, what did they do? They said, oh, hold on, no, we're not liable. We can't be held liable to you, for the simple reason here is that we can't be held liable on the basis that we had an exclusion clause here. And the court said here, well, that actually the contract was concluded when the plaintiff put the money into the machine and the offer of parking had been accepted. And the court ruled that those terms that were displayed inside, that they weren't actually a part of the contract. And why? So they weren't part of the contract because they came after the contract was concluded. So therefore, the notification wasn't inside in the car park, wasn't validly incorporated because it was only given after the contract had been agreed and had been concluded. So these two cases now, ladies and gentlemen, cases of Ollie and Marlborough Court and the case of Thornton and Shoe Lane Parking Limited, these two cases, what they do for you is they illustrate to us all that it's important that if you want to rely on the exclusion clause, that timing is really important, that you have given notice of the exclusion clause before the contract has actually been completed. Okay, and the judges and academics and critics have all said to agreed over the years that when there's an exemption clause or exclusion clause, and the more onerous the exclusion clause is, that the greater the efforts that must be taken to bring it to the attention of the other side. And Lord Justice Denning, who's a famous judge in England, he decided this case of Thornton and Shoe Lane Parking Limited. And he said, like, because the clause in Thornton, the one that was inside in the car park, because of the width of that clause, he said, given the width of the clause and given how the scope of it was so broad, the more that should have been done to bring it to the other party's attention. So the general principle that has emerged from the case law is that where there's a clause, the great steps should be taken to bring it to the other party's attention. Here in case of Western Meats and National Ice and Cold Storage, this case involved the defendants, who were operators of a meat storage warehouse, found themselves unable to actually locate the plaintiff's consignment of meat in their warehouse. And what the defendants did here was they tried to rely on their exclusion clause contained in their conditions, which stated that meat was stored at the owner's risk. However, it wasn't actually incorporated into the contract because it was on the back of letters and storage documents. The court said that that wasn't actually part of the contract. So again, this case reaffirms that principle that I was just talking about, that, you know, it must be, steps must be taken to bring it to the attention of the other party so that they actually have notice of the exclusion clause. And then a further way in which, and this is the final way in which an exclusion clause could be incorporated into a contract. This might be the evidence that somebody might rely on and say, well, it's incorporated in our contract because we have a history of dealing. We've been dealing together for a long, long time. and therefore the exclusion clause was incorporated into our contract on that basis. So like the party who's seeking to rely on the exclusion clause might say, we had previous dealings with each other, and therefore they're bound by the exclusion clause on the basis of this dealings. Okay. Now, of course, there's going to have to be evidence that there was dealings between the parties. You have to show that there is some bit of a pattern of dealings between the parties. And we see two cases here, Miley and McKechnie, and Hollier and Ramblers. And these two cases give us some principles on what constitutes a course of dealing or what constitutes previous dealings. And in Miley, this was one of the dry cleaner cases. There's often a lot of cases here. There's, I suppose, one thing to be aware of, like, there's no hard and fast rule on what constitutes a course of dealings. It's just that whoever is relying on the exclusion clause is saying that we've previously done business between each other on the same terms. And in Miley and McKechnie, the plaintiff left a garment into the defendant's shop to be dry cleaned, and the customer, the plaintiff, was given a notice and a receipt marked important, and basically that receipt, set out that all orders were accepted without guarantee, and that document, that receipt, directed the attention to conditions printed on the reverse. Now, the plaintiff in this case, she regularly availed of the services of the dry cleaners, and every time she used the dry cleaners, she was always given such a receipt. And now she claimed that she did know that there was obviously some conditions on the document, but she said she never read it. She never read any time of it. So the issue arose here was, well, did this practice amount to course of dealing? Was it enough to say that the clause was incorporated into the contract? And the court said, yeah. The fact that she didn't read the conditions, and the fact that the ticket was given to her after the contract was concluded was unimportant, given the course of dealing between the parties. So the court ruled here that the defendants were entitled to rely on the exemption clause, given that there was a course of dealings between the parties. Now, in contrast to that, in Hollier and Rambler Motors, in this case, the plaintiff was seeking damages from the defendant garage. They're seeking damages from the defendant garage when their car had been in for repairs and had actually got damaged. And they were suing, and every time the plaintiff left the car in, the plaintiff was given a receipt. And this time, now that the plaintiff was trying to look for damages to the car, the defendant company, the garage, said that they were going to rely on the exclusion clause, and they said that the plaintiff should have been aware of their exclusion clause. And the court said here, actually, no, there is no course of dealings here. The court reasoned that a series of isolated transactions couldn't actually be a course of dealing in order to incorporate an exemption clause into a contract. So this is what the court said here. 3 or 4 past dealings over a period of 5 years isn't enough to amount to a course of dealing in order to incorporate an exemption clause into the contract. Therefore, it would seem that we need to have something very regular and very consistent in order for it to amount to a course of dealings. Okay, and Sperling and Bradshaw is another case that talks about incorporation through a course of dealings, and I won't go through that case at the moment with you, but you can read it there for yourselves. But just to say that in the case of Sperling and Bradshaw, this clause was validly incorporated and the defendants couldn't sue for damages. Okay, so that was what emerged in Sperling and Bradshaw. Now, other factors that the court will have regard to when it comes to exemption clauses is, has it been freely negotiated? Is it contrary to the court's sense of fair play and equity? And has it been drafted in the clearest possible terms? So these are other relevant questions that arise for analysis or arise for consideration. Now, what I'm going to move on to now, folks, is once you've identified that the exclusion clause is part of the contract, the next thing to do is see, does it cover the loss, or C, does it cover the liability in question? So this is the rules of construction have to be satisfied. All right. So rules of construction, how will you know whether the exclusion clause covers the breach or covers the loss? You'll only know if you actually read it and interpret it. Okay. So just to reiterate it again, folks, in talking about exclusion clauses, an exclusion clause is a clause which attempts to limit or reduce your liability in the event of a breach. And for an exclusion clause to stand up, in other words, for you to get the benefit of that exclusion clause, you've got to demonstrate, one, that it's part of the contract, so it's incorporated, validly incorporated, or secondly, you've got to demonstrate that it is worded in such a way that it covers liability. In other words, that it's worded in such a way that it actually covers the loss. So the well-drafted exclusion clauses will have them carefully and clearly drafted as best they can to try and make sure that the exclusion clause holds up. And if I could just mention this word here, unambiguous, it's important that the exclusion clause, for the party who wants to rely on it, it's important that the exclusion clause is clear and is free from ambiguity. Because if it's in any ways ambiguous, courts will tend to lean against it and will tend to give the benefit of the exclusion clause to the other party. Okay, or like won't actually allow the exemption clause to cover the liability. Okay, so this is the second part, and this is the part sometimes people forget. Think, well, it's a corporation, the contract. Here we go, bingo. We're fine. We've no liability because our exclusion clause is part of the contract. You're only halfway there when you have it incorporated. The second, when it's proven that it's incorporated, second part then is to make sure that it covers the events that have occurred. Okay, so therefore, for a person who's going to rely on exclusion clauses, I suppose the words I give are make sure it's drafted correctly and exactly. Okay, so the rules of construction that we're going to look at here, folks, and the first rule is applied by the courts, and it's a rule that the courts used to interpret such a clause, and so that's the contra proferentum rule. And what does this rule say is that the principle behind this rule is that clauses in contracts should be written in clear and in precise terms. And this rule provides that where the meaning of the law is unclear or is in any ways ambiguous, the court will adopt the meaning that's least favourable to the party who wants to enforce the contract. Okay, so if it's drafted in any ways with ambiguity, or it's unclear, or it's vague, or in any way like that, what the court will do is they'll give the benefit to the weaker party. In other words, they'll give the benefit to the party who it's been enforced against, and the least favourable interpretation of it to the party who wants to actually rely on it. So this contra proferentum rule, this would be a rule that was actually developed by the courts, but it's actually written into Irish law now. It's written into Irish legislation, because Article 5 of the EC Unfair Terms and Consumer Contracts regulation says that if a clause is uncertain, the meaning that's most favourable to the consumer shall prevail. Okay, so it's absolutely there. It's part of the law. Okay, so therefore the meaning that's most favourable to the consumer will prevail. So that's where the clause is in any ways ambiguous, any ways unclear. So the courts give the benefit to the weaker party. Okay. A second rule of construction that's used by the courts in interpreting these clauses is the fundamental breach rule. And what this rule says is that an exemption clause is going to be invalid if whoever is trying to enforce the clause has committed a fundamental breach of contract, okay, or any exclusion clause which attempts to exclude a core contractual obligation is automatically invalid. Okay, so in other words, a party isn't going to be able to use the exclusion clause for that clause where they're in fundamental breach of the contract or where they have excluded a core obligation of the contract. Okay, principle being here that you cannot actually exempt. You can't actually exempt the main purpose of the contract. Okay, that's the fundamental breach rule, and we see the fundamental breach rule being applied in the case of Clayton Love. This was an Irish case, and the court ruled in Clayton Love that a company couldn't rely on the exemption clause to avoid paying damages. In this case, the defendants had contracted to transport frozen scampi from Ireland to England, and the defendants they transported the goods at the wrong temperature, and with the result that the scampi was inedible by the time it actually reached England. Okay, the defendants attempted to rely on the exemption clause, and Supreme Court decided this case, and the Supreme Court said you could never have an exemption clause which would cover breach of the party's key obligations under the terms of the contract. Okay. Now, nowadays, the courts mightn't actually apply that rule very strictly. They'll consider all the factors of the case. There has been some legislative response to exemption clauses in the EC Unfair Terms in Contracts regulations of 1995 and 2000, and so they protect consumers, these terms which have been included in the unfair terms and consumer into the consumer regulations. Okay, so these regulations, the EC Unfair Terms and Consumer Contracts regulations, they apply to contracts between businesses and consumers. So, for example, a contract between a service supplier and the individual consumer. And if a court finds that a particular term is unfair, it'll be void and incapable of enforcement. And then the sale of goods legislation, and this is probably legislation that many of you are already quite familiar with, and like this provides that where a business is dealing with a consumer, the business cannot insert a clause into the contract exempting liability in relation to merchantable quality or fitness for purpose of the goods or services, and so on and so forth. Okay, and then the third rule, final rule that we have then that the courts might apply with respect to exemption clauses is the exclusionary rule, and this means that you can't use this means that the exemption clause will be inapplicable to certain eventualities. So this was applied in the case of Ronan and Midland Railway. Here the plaintiff agreed to employ the defendants to ship the cattle from Dublin to Liverpool, and he was given a receipt with a wide-ranging exclusion clause to the effect that the cattle were to travel at the owner's risk. Cattle were very badly damaged and by the defendant's employees, And the court held here that the phrase "at owner's risk" did not exclude liability for deliberate acts of destruction. So therefore, the exclusion clause didn't actually hold and didn't actually stand there in that case. Okay, so just to reiterate it then, we've looked at the rules of construction, we've looked at the contra proferentum rule, the fundamental breach rule, and the exclusionary rule. Okay, there's some questions there that you can go through in your own time, guys. And I want to look at a question with you now while we're on this. Okay, I just want to get the question. So on Moodle. Okay, folks, this is a short question that's available on Moodle, and I'll go through it with you now. Alex is in Cork for the first time and decides to leave his bag containing his €300 camera at Train Limited's left luggage lockers for the day. He places his bag in the locker, and after inserting the €10 fee, the door locks and a ticket is issued. The ticket states that Train Limited are not liable for any loss, damage, or theft to items valued over €100 left in lockers. And Alex's locker is broken into by Fred and his camera is stolen. So the issue which arises here is, can Alex claim €300 from Train Limited? So there is an exemption clause there. So because the ticket states that Train Limited are not liable for any loss, damage, or theft to items valued over 100 left in lockers. So the issue there, folks, is, can Alex claim the €300 from Train Limited? Is it A, no, because his camera is stolen by someone other than Train Limited? Or is it B, no, because the exemption clause states that the limit is €10? Or is it C, he can, because an exemption clause is only valid if it's signed? And D, he can, because the exemption clause, he can recover the €300 for his camera, because the exemption clause was dispensed after the contract was made. So answers, please. Okay, so some very good answers coming in there. Very good. And anyone else, guys? There's more in the class than the people who have contributed by giving an answer in the chat. Any attempt is better than no attempt. Good. Okay. Okay, good work, guys. Well done on participating. Good work for participating in the chat. A number of people have said A, and A said no because his camera is stolen by someone other than Train Limited. No, that wouldn't be the relevant response. A number of people have said B, no, because the exemption clause states the limit is €10. That one is kind of only a red herring and isn't actually helpful. And then you have C, exemption clause is only valid if it's signed. An exemption clause doesn't have to be signed in order for it to be valid. And D, yes, he can recover because the exemption clause is dispensed after the contract was made. Yeah, in fact, actually, that D is the best answer there. And if you go into Moodle and you go through this short quiz, there's only 3 questions there in that quiz, but if you go into it, folks, you will get feedback on your response. So if you do go into that particular one, you will get the feedback on it. Okay, so well done, guys, there. So D is the relevant answer. Okay, well done, and thank you to those of you who participated in the chat there and participated in giving answers. It's noted and it's appreciated. On Moodle, folks, I have included a worksheet for you on exemption clauses. You don't even have to fill it in. The work is done there for you on it. Okay, so it should be a useful tool for you. I want to look at a question, and it's in your question booklet. For whatever reason, my document won't open. Now, folks, there's a question there on page 26, I think, roughly, of your questions. It's the one about Cassidy. I think it's page 26. Yeah, 25 even. Okay, so I just go through it with you guys, and you'll see. Right, Cassidy recently booked a spa break with the Hamptons County House Hotel and Spa. She booked this trip over the phone and paid for it by credit card at the time of the booking. After checking into the hotel, she went down to the spa where she had an appointment for the pamper package. At the spa reception desk, she was given a key to a locker in the changing room and told to go and change into a robe, and that a beauty therapist would then take her into the therapy suites. In the changing room, she noticed a sign on the wall which stated, "Items are left in the changing room and lockers entirely at the user's own risk. The Hamptons County House Hotel and Spa does not accept any liability, whether express, implied or statutory, for the loss or theft of or damage to items left in the changing room," so on and so forth. And as Cassidy was wearing her diamond engagement ring when she checked into the spa, she decided to remove it in case the oils from the beauty treatment caused it to tarnish. She put it into the locker and locked it, and she believed that the ring would be safe in the locker as she had possession of the key. Now, we're told more then in the third paragraph was that when she had her treatments and she went back to the changing room, she was shocked to discover that her locker had been emptied and that her ring and purse were missing. So she had discussions with the receptionist, and she learned that another client told the receptionist she lost her locker key, and the receptionist actually gave her a master key that could open all of the lockers. And it now transpires that more than a dozen different lockers were opened and the contents stolen. And Cassidy has contacted the managers and informed them that she plans on taking legal action against them in respect of her stolen ring and purse. And the hotel are denying responsibility, and they said they're going to rely on the exemption clause in order to escape liability. Okay, so it looks like it's an issue of whether they can rely on that exemption clause or not. So the question then is straightforward. Explain any two methods by which an exemption clause can be incorporated into a contract. So for part A there, folks, it asks you to explain any two methods by which an exemption clause can be incorporated into a contract. So what are the methods of incorporation that you could talk about there, folks, in part A? What are the methods of incorporation? What would we say there as being a method by which an exemption clause can be incorporated? Okay. Okay, good. Yeah, so we're having a few comments there in the chat. So one of them being by notice. Good. Another method could be through an unsigned document, provided notice is given. Good. And is there anyone else out there, guys? You could say by signature, or you could say through a course of dealings. And then you have to see whether or not this clause is incorporated into the contract. So assess if it's incorporated into the contract, and you do so by looking at those rules. Like there's no signature here. And so look at the timing of when she got notice of this exclusion clause. And then the last part then, assuming that the clause is part of Cassidy's contract, outline whether the fundamental breach rule would or would not allow the hotel to escape liability in the situation. So it's anticipating a discussion of fundamental breach rule, anticipating a discussion of the rules of construction there in Part C. So overall there, guys, you see that question examined the rules of incorporation, and then it examined the rules of construction. Okay, and question 2, I think, is quite similar there. You have to advise the parties of their legal position, define it, discuss the methods of incorporation, and assess whether the hotel can rely on the exclusion clause to avoid liability. So that seems to be the requirements there in those two questions. The questions are quite similar. Okay, so then to summarize what we have done today, folks, we have looked at the differences between terms, conditions, and warranties. And we know that if it's a warranty, you only get damages, you're not entitled to actually rescind the contract. We've also then today, we've looked at an exclusion clause, we've defined it. We know that an exclusion clause is a clause which attempts to limit your liability for a breach of contract. And there's 2 core things surrounding an exemption clause: that it must be incorporated into the contract, and it must be worded in such a way that when the court is reading it, that it actually covers the loss or the breach in question. Okay, so if anybody has any questions, or if anybody has something that they wish to have clarified, please raise it now. Otherwise, I've no further material that I'm going to cover today. We'll still be working on some contract law next week, and I will see you for class then on Monday. If you have any questions, please do raise them, and we'll try and sort it out, help you out. Okay, thanks for your attention, and thanks to those who have contributed and contributed in the chat and otherwise. Thank you.